Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I want to talk about COT3 agreements. The COT3 is a form of settlement agreement, either between an individual who is threatening to bring a claim against a particular employer via Acas, where they've been engaged in early conciliation, so pre a tribunal claim being brought, or indeed settlement of that tribunal claim, so where the parties have agreed to suspend the litigation, often in return for an individual receiving a certain sum of money. Then there will be this agreement put in place that draws a line under the issues that have been raised up until that point, and the parties essentially agree to walk away, and in particular walk away from legal action. I say that usually there's a sum of money involved. It might also be things like, for example, an employer agreeing not to make a costs application against a person who has threatened them with a claim or is bringing a claim, and to drop hands maybe in an action where the employer has got a claim also against the employee for something. So think about it very much in terms of the parties agreeing this parting of the ways that is going to bring an end to the litigation. It's called a COT3 because years ago that was the name of the government form that was used for it. There isn't any magic these days to it being called a COT3. We're just stuck with that historical name. Typically we're talking about a document that's only a couple of pages long, certainly less convoluted and detailed than, for example, a settlement agreement might normally be. Obviously, it will deal with things like what sum of money has been agreed, when is that going to be paid, how is it going to be paid, is it going to be paid to somebody's solicitor who's acting for them, is it direct into somebody's bank account, and these days obviously we're all taking precautions over putting people's payment details and things like that into documents, so there might need to be some behind the scenes confirmation that we're sending money to the right place. Typically there's be a clause referring to tax, so if the sum of money that somebody's receiving is for wages that are owed or things like holiday pay, then those things are going to be taxed. So if you would as an employee be being taxed on those things if you were still in employment, then they're still going to be taxed when you receive payment for them. If actually the complaint has been around something like unfair dismissal or discrimination, and actually the sum of money that's being paid is compensation or damages in relation to the litigation, then typically those payments are made tax-free up to a certain level. It's often the case that the employee wants to have a reference included and detail around what that looks like, who's going to be giving it, what it's going to say, those sorts of issues. And then there will be a clause that brings the end to the potential claim or the claims that are in existence. And there will be possibly clauses around things like if the employee doesn't abide by the agreement and breaches it, that perhaps they have to pay the money back if they've received the sum or it ceases to be payable. So all of those things are quite normal in a settlement agreement. The other thing that is always really normal in a settlement agreement is the employer wanting a confidentiality provision. Go back to the beginning where we talked about both parties walking away, it being a line in the sand. obviously an organisation isn't going to want to pay somebody a sum of money if they're going to carry on spreading things about them on the internet, publishing opinions in blogs, involving the press, all of those sorts of things. It genuinely needs to be that the employee concerned is also understanding that this is an end to this. We're drawing that line in the sand and we're going to move on with our lives from it. So sometimes it can be controversial that employees balk at that principle and they don't like the idea of confidentiality and they want to be able to tell their friends what's happened. Really, if you're going to be successful in getting a settlement, you're probably going to have to accept that the employer organisation is going to want that principle, because it's the only way of there being an end to things. So it's not personal to you. If you are in that boat, it is just the way things are generally. So it's not at all unusual to have that provision in a settlement agreement. It is quite normal. There's often a provision that says you can discuss the settlement agreement with close family, as long as they then also aren't putting things in the press and on the internet and setting up web pages and things like that. So, it's this general principle of everybody bringing things to an end. In terms of the process that is followed, it can be something that people aren't completely familiar with. So I'll run you through what typically happens. So there's typically offers made by one side or the other to reach some kind of an agreement. Typically at that point, the parties are hashing out, what their legal arguments and strengths and weaknesses of the case are. And that leads to, hopefully, an agreement. So at some point, the terms of that agreement are agreed. So at that point, we've got the headlines agreed. Then there will be putting together the wording of the COT3. Typically, the employer's side is going to draft that, and the employee side will have an opportunity to check the wording of it, check that they're happy with it. Once that paperwork is agreed, in the sense that everybody agrees the wording that's going to be used, Acas can then confirm to the parties. It always used to be by telephone, but sometimes these days it's email. The officer who's helping those parties will confirm you now have a binding agreement. So at that point, that is when things have ended. And the Acas officer will notify the tribunal, if there are tribunal proceedings, that things are at an end and the case would be withdrawn from the list at the tribunal. Acas will then put the wording that's been agreed onto headed note paper and will send it with instructions to the employee for them to sign. The employee is then tasked with forwarding it to the employer or their representatives if they're acting for them, and then the employer will sign. Remember, the agreement's already binding because everybody's reached that place already. It's just the paperwork is following up, and that might be 24, 48 hours later. Once both parties have signed the paperwork, then the employer is going to process payment. So typically you'll find in a COT3 agreement it's probably 21 days before payment is processed. So there's likely to be some time elapsing between when Acas has said you've got a binding agreement and when the person actually receives their payment. Obviously that's subject to negotiation between the parties, but 21 days is quite normal. Sometimes it's longer if a particular employer has systems that take a particular length of time to do things. For example, payroll being run from a different organisation, and then the person is paid their money and everybody hopefully is happy and walks away from each other. Hopefully that gives you a very quick gallop through how COT3s work and is useful information. If you've got any questions, it's adenton@refreshinglawltd.co.uk. Thanks.